Hi, it's Bill. I'm often asked what people can do if they've gotten divorced and their former spouse is not doing what he or she was ordered to do in their divorce papers. The answer is simple. You can file a motion for contempt. A motion for contempt is simply a request to the judge who heard your divorce case to punish your former spouse for not complying with your divorce papers. Some of the reasons that might cause you to file a motion for contempt include your former spouse isn't paying you the court-ordered child support or alimony, or your former spouse isn't giving you the court-ordered visitation or parenting time, or your former spouse isn't refinancing or selling the former marital residence as required. A motion for contempt is handled just like a new divorce case. It must be personally served on your former spouse, and you have to schedule a hearing before the judge who heard your divorce case to ensure action is taken on your motion. If you file a motion for contempt, you must prove that your former spouse violated one or more provisions of your final divorce paperwork. If you do that, your former spouse must then prove that he or she had a reasonable excuse for that violation. The person who wins the motion for contempt is often awarded attorney's fees by the judge from the loser. Before filing your motion for contempt, however, it's always advisable to try to work things out with your former spouse by phone, email, or text. Being able to show that you tried to work things out will help you show the judge that you tried to cooperate before going to court, and it will increase the likelihood that the judge will rule in your favor and award you attorney's fees from your former spouse. If you're considering filing a motion for contempt, or if you've been served with a motion for contempt filed by your former spouse, call us for help at the Gentry Law Firm at 770-425-5573. Stay well, and we'll talk again soon.